And I do believe the AC is on. I don't know if it's at 40% or 50%, but I think it's much better than it was yesterday. So if there are any issues, let me know. State, are there any motions?
Yes, Judge, the state moves to reopen the evidence.
All right, any objections?
Yes, Your Honor, the defense objects.
All right, and the court has already previously made a ruling. The court will overrule your objection. The state you will be allowed to reopen.
Your Honor, we move state 37A into evidence at this time.
Any objections?
No objection, Your Honor.
All right, 37A is admitted into evidence.
And then we rest and close.
All right, defense.
Rest and close, Your Honor.
All right, thank you. Ladies and gentlemen of the jury, what will happen now is I'm going to read to you the jury charge. You will be allowed to have a copy of the jury charge back with you in the jury room. After I read the charge, both parties for the state and the defense will have an opportunity to provide closing arguments. Charge of the court. Members of the jury, the defendant, Kevin Debnab Jr., stands charged by indictment with the offense of aggravated assault with a deadly weapon, namely a firearm alleged to have been committed on or about the 27th day of April 2019 in Bexar County, Texas. To this charge, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits aggravated assault if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2, bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. 3, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person intentionally threatens another with imminent bodily injury if it is the person's conscious objective or desire to engage in conduct constituting a threat of imminent bodily injury. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person knowingly threatens another with imminent bodily injury if the person is aware that the person's conduct constitutes a threat of imminent bodily injury. 4, now if you find from the evidence beyond a reasonable doubt that on or about the 27th day of April 2019 in Bexar County, Texas, the defendant, Kevin Debnab Jr., did use or exhibit a deadly weapon, namely a firearm, and Kevin Debnab Jr. did intentionally or knowingly threaten imminent bodily injury to Michael Cruz by shooting at or in the direction of Michael Cruz with said deadly weapon, then you will next consider whether the defendant did so in self-defense as instructed in paragraph 5. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty and do not consider paragraph 5. 5, a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place as set out above. And 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. A person in lawful possession of land or tangible, movable property is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate the other's trespass on the land or unlawful interference with the property. A person is justified in using force against another to protect a third person if, under the circumstances as the actor reasonably believes them to be, the actor would be justified in using force to protect himself against the unlawful force or unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect, and the actor reasonably believes that his intervention is immediately necessary to protect the third person. A person is justified in using force against another to protect movable property of a third person if, under the circumstances as he reasonably believes them to be, the actor would be justified in using force to protect his own property, and the actor reasonably believes the unlawful interference constitutes attempted theft of property. A person who has a right to be present at the location where force is used, who has not provoked the person against whom the force is used, and who is not engaged in criminal activity at the time the force is used, is not required to retreat before using force. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Now, keeping in mind these instructions as they apply to the offense of aggravated assault with a deadly weapon as charged in the indictment, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant committed the offense of aggravated assault with a deadly weapon as charged in the indictment and instructed in paragraph 4, you must decide whether the state has proven beyond a reasonable doubt that the defendant's conduct was not justified by self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that on or about the 27th day of April 2019 in Bexar County, Texas, the defendant, Kevin Dabnab Jr., did use or exhibit a deadly weapon, namely a firearm, and Kevin Dabnab Jr. did intentionally or knowingly threaten imminent bodily injury to Michael Cruz by shooting at or in the direction of Michael Cruz with said deadly weapon, as alleged in the indictment and charged in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Kevin Dabnab Jr. reasonably believed that Michael Cruz was using or attempted to use unlawful deadly force against Kevin Dabnab Jr., and 2, Kevin Dabnab Jr. reasonably believed that the use of deadly force and degree of deadly force used were immediately necessary to protect himself against Michael Cruz's use or attempted use of unlawful deadly force, then you will acquit the defendant and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that on or about the 27th day of April 2019 in Bexar County, Texas, the defendant, Kevin Dabnab Jr., did use or exhibit a deadly weapon, namely a firearm, and Kevin Dabnab Jr. did intentionally or knowingly threaten imminent bodily injury to Michael Cruz by shooting at or in the direction of Michael Cruz with said deadly weapon as alleged in the indictment and charged in paragraph 4, and you further find from the evidence beyond a reasonable doubt, one, Kevin Dabnab Jr. did not reasonably believe that Michael Cruz was using or attempting to use unlawful deadly force against Kevin Dabnab Jr. Or two, Kevin Dabnab Jr. did not reasonably believe that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Michael Cruz's use or attempted use of unlawful deadly force, then you will find the defendant guilty of aggravated assault with a deadly weapon as charged in the indictment. 6, our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. 7, written or recorded statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone or computer, the internet, or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case, or to conduct any research about this case until I accept your verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication was or is intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. The forms are not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty on the indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, the presiding juror should notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectively submitted, Judge Stephanie Boyd of the 187 District Court, and suitable verdict forms are attached. State, are you ready to proceed?
Yes, Your Honor. Marcus just has to switch over to media.
Yes.
Please, the court. Counsel. Members of the jury, good morning. Okay. You don't have to struggle finding truth. The truth in a story is easy. It makes sense. The pieces of the puzzle fit together naturally. All right. Closing is broken up into two parts for the state. And I'm going to do mostly the law. Okay. Marcus is going to come after, and he's going to do most of the facts. So I want to share with you that there's two different ways to get to the truth here. A very easy flat road, which is on that night, this gentleman, while in Michael Cruz's car, had a weapon, had a loaded, stolen firearm and a knife. He was pulled out of the car, he attacked him, and he shot at Michael Cruz that night in the dark on his own property. That's easy. That's the aggravated assault. That's the truth. It's corroborated by the evidence. That's easy. And so you might be wondering, why then do I hear all this self-defense stuff? So let me say one thing first. What the judge just read, if you caught like 17% of it, that's fine. This document goes back to the jury room with you, all right? That's the judge's roadmap. Although it's a little bit convoluted, and that's what I'm going to try to clear up. And you can read this and you can make sense of it, but I'm hoping that I can simplify it. So initially, I would tell you that the truth is easy. He committed an aggravated assault that night. You have proved that beyond a reasonable doubt in this period. However, if you want to take the windy road up the mountain, where we have to consider self-defense and defense of land, and defense of property at night, and defense of third persons, I'm going to take you there, all right? So the simple corroborated truth is that was our charge in the indictment, and we proved that Debenham had a loaded 9mm, shot at Michael, he felt in fear for his life, then he stabbed Drew, then he got caught, then he punched the story. And let me just tell you real quick, the way the law works in Texas is when you get caught, if you say self-defense one time, that can trigger this whole process. This instruction, self-defense, even if you're thinking to yourself, which I'll be truthful, we are, this is not self-defense. You get all of these instructions. The law affords all of the rights to the accused. So it is a little bit unfair that the person who has to deal with this in the middle of the night with the 5-year-old who's working a second job, right? Who's just trying to take the car seat out of the car to provide for his family, who's not doing anything wrong. It doesn't seem like any of the rights go their way. The complex, rule intensive, but exact same truth. This is going to be the path up the mountain. It goes like this, right? It's going to be a little bit auctioneer style. You first have to decide, that's what this jury charge said. You first have to decide, did we prove Kevin Devnam shot at her in the direction of Michael Cruz that night with the deadly weapon? And was Michael here? Did we prove that? The answer is yes. Then we go to question number 2. Okay, we proved that, but are you going to let Kevin Devnam off the hook? Because he was acting in self-defense, right? That's question number 2 as we drive up the mountain. Marcus told you in voir dire that this is the definition of self-defense. Kevin Devnam had to reasonably believe that his force was immediately necessary to protect himself from unlawful force. Okay, here we go. You saw the chair. The chair must have all 4 legs to stand up. You knock one of the legs off the chair, self-defense falls off the chair, and you don't get it anymore. Everybody said they understood that in voir dire. Everybody's clear on that point. So, first of all, the belief that's reasonable is an objective point. Because it occurred to me last night, Kevin Devnam might really think that he got to use self-defense in that instance. He might, in some weird way, not understanding the law or whatever, or he was intoxicated, I don't know. He might really think that. I didn't realize that till last night. But that is not the law. The law is objective. A reasonable, objective person placed in that situation. Would a reasonable, objective person think, I better pull out my piece and try to shoot this guy because he caught me breaking into his car? And I would tell you that that is not reasonable, and that is not what an objective person said. So the first time we can strike off that number 2, no self-defense, is he is not acting reasonably in an objective standard that night. But I'll give you more. The charge will also tell you that Michael can defend his property at night from an unlawful trespass on his land or an interference with his property. That is Michael's right. And that is exactly what he did. And so if Michael is using lawful force to pull this guy out of the vehicle, and there's a struggle and a fight, throws some punches, and then gets shot at, Michael is acting lawfully. And if Michael is acting lawfully, then there's also no self-defense. Because that word in the charge, I'm giving you some snippets here, but I just want to focus in. The force being used against Kevin must be unlawful. But if Michael is acting lawfully, because the law allows him to protect his family, his property, his car, stop a trespass, then it is not unlawful. And you lose the leg of the chair of unlawful. And that makes it not reasonable, and that means self-defense falls off the chair. So we're left with 1 ag assault, but 2 no self-defense. But there's more. Michael can also defend Jacqueline's property. The vehicle, the car seat, the land, the house. This is Texas, right? That's your spouse, your common law. That's all of her stuff too. You can defend your family in their home at night. That is totally lawful. And that means, once again, no self-defense for the defendant, right? Number 2, we nix it off again. Might seem redundant at this point. You're like, well, how many times is Tom going to cancel self-defense? Well, there's a lot of ways we cancel it. So again, the same unlawful argument has to be used. Michael can lawfully defend that property or the people on behalf of Jacqueline or their young son. So again, lose that leg, lose that reasonable, lose that self-defense. But there's more. Drew can defend Michael. He's an invited guest on the property. He's a resident. He can come out to Michael's aid. So the defendant also can't claim, well, self-defense against Drew. Okay, maybe you're not giving me self-defense against Michael, but now I say self-defense against Drew. No. Drew can defend Michael, who was unlawfully attacked, trespassing, and up to criminal activity in the nighttime in the first place. So that's another reason why he does not get self-defense. Just keep knocking these legs off the chair. Finally, the charge says that duty to retreat is for this guy, for Kevin, right? It says Kevin, if he had a right to be present at the location where the force was used, if he had not provoked that situation, and if he was not engaged in criminal activity, then Kevin gets to stand his ground, right? You've heard that term in the news, no duty to retreat, stand your ground. Kevin only gets those things if he is complying with all three of those. They're called conditions precedent in the law, right? You gotta have all three if you get to stand your ground. And that's just not the case. He didn't have a right to be present at the location, and he was definitely breaking the law at the time he is now claiming self-defense. No self-defense for you. We knocked our legs off, and this time we knocked off our necessary as well. It wasn't necessary because of our duty to retreat. Some other points of law for you to remember. Just gleaning points out of the chart. You don't get police reports. The testimony was evidence, but the reports themselves don't go in evidence. There's a specific rule for each of these for us lawyers, so if you want them, you don't get them. I'm sorry. Intoxication is not a defense, does not excuse his actions. You can't consider things not in evidence, like if you're listening to a video and it all of a sudden mutes. Don't be worrying about what was under the muted sound. You just consider what is in evidence in front of you. There's no transcript of the defendant's interview. If you're listening and you're like, what is going on there? I'm sorry, turn the volume up and try your best, but I would submit to you, it's a whole bunch of baloney. There are no physical statements allowed into testimony. The statements you got was, into the record. The physical statements you got were what the witnesses said, right? Their testimony is the evidence. And finally, you are the jury for this case only. Don't be worrying about other charges and other cases. Is there one for Drew? That's not for you guys here today. You're the jury for this particular case, okay? Debnam's tale, and this is where we get away from the truth is easy. Debnam's tale is he's walking down the street, minding his own business, drinking his 2 beers. He stretches his back somewhere in these folks' yard. I'm not sure quite what he's admitting to. Michael attacks him for no reason. Drew runs out and shoots the gun near his face, but it's somehow in a position where Debnam can bite his hand while he's face down on the ground. And I want to remind you what defense counsel said to you in opening. My client never had the gun. He didn't shoot the gun, right? That's their defense. And they stuck to it. And it's just not the truth. It's just not the evidence. It just doesn't prove it. So ultimately, you get to decide. So sometimes in cases, we don't put the defendant's statement on or whatever. We gave you the whole tomato here, right? We put the defendant's statement on. You might be listening to him, well, this guy's not admitting to anything. That's fine. You guys can have all the facts and make up your minds about what's the truth and what's not the truth. You get to decide who's telling the truth and why. But I can also share with you, let me go ahead one, that the number one most important thing I would ask you to do in the jury room is look for corroboration, right? I didn't fire a gun, explain to me why there's GSR in your hand. Your right hand, which the neighbor said, I stepped on his right wrist and removed the weapon from his right hand, which was then found on the porch. And it goes on and on and on and on. I want you to look for that corroboration. And I want you to ask yourself, when you get to hear defense counsel's theory, how does this make sense? Because it would mean that if the brothers attacked him for no reason, they called the cops on themselves, allowed the neighbor to produce the weapon that they somehow had, followed up by coming to court 2 years later to keep telling their same story, even though it's consistent with all the evidence and everything like that. And they found it emotionally important enough to come to court after their second child had been born 5 days prior to giving testimony in court. I have little ones at home, and I could not imagine coming to do this 5 days after one of my children was born. So you can feel that palpable emotion of what's real, okay? Beyond a reasonable doubt is in the charge. We've given you all the pieces. I like to think of a case as a puzzle. We bring in all these different people and all these pieces, and now you see what the picture is, right? You see what the picture is, you have all the pieces, you can put them together, and you can see a clear picture of exactly what happened. At the end of this, Marcus is going to come up here and he's going to ask you to find Mr. Debenham guilty. And I'm going to simplify it even more. The last page in the jury form looks like this. The bottom paragraph is finding him guilty. Whoever's the presiding juror, you sign right there. You hold Mr. Debenham accountable for his actions. This is literally the worst nightmare of a dad going out to take his kid's car seat out of the car, right? This is what parents fear about in the night. Hold Mr. Debenham accountable.
Defense?
Thank you, Your Honor. Okay. Just as we get in board here, you have to look at what the actual charge is. You said beyond a reasonable doubt, there's 3 words and each one of them has meaning. Aggravated assault with a deadly weapon has specific meanings. Judge gave you the instructions and gave you basically a roadmap on what he's actually charged with. And I'll tell you right now, I wish that my client had agreed with Detective Alvarez. It would be a much easier case to defend. But he has consistently, when he was first handcuffed and laid on the ground, he told you, no, I didn't have a gun. They shot the gun. He told Detective Alvarez, I didn't shoot the gun. I didn't have it. Now, there's some things. The prosecution made a very good point. You have to look at the corroboration, the things that point toward and against a specific fact being true. Some things you have to think through. Debenham said that the gun was fired past his face. And if you watch the interrogation room video, periodically, it was repeated. He'd go up and he had an irritation on his face. Detective Alvarez said, you got really beat up. And he had. He'd gotten choked. How do we know he was choked? Because Michael Cruz told us he choked him. He used the term, I was trying to choke him out. All right. His voice was obviously somewhat impaired on the video. But he was interrogated forcefully for 2 hours. That story never changed. The knife charge is just chaff, basically. It's thrown in there. My client admitted that he used a knife. Well, if he was attacked by 2 men, at least one of them trying to quote, choke him out, why did he use the gun? Why did he take a knife out to defend himself and stab somebody in the knee? If you read the charge, you're going to see that there are requirements for somebody to be threatened with a gun, pointed at or shot toward. Michael Cruz played to be the only person there with Mr. Debenham when that gunshot went off. Did not ever see a gun in my client's hand. He never saw a muzzle flash pointed toward him. I haven't seen a muzzle flash. Now, the burglary of the car issue. And this is part of the reason that we went through so much effort during the board here on the one witness rule. Michael Cruz is the only person that told you that Mr. Debenham was in the car. But do we have any corroboration? Was there any damage to the car that was broken into? Jacqueline said no. Was anything missing from the car? Again, Jacqueline said no. The photographs that you saw show the car rolled into the driveway and in the seat that my client was supposed to be sitting in, the car seat is in that seat. The driver's side back seat. And then we have in the dark, we have this tussle, this fight, this struggle. And Michael Cruz told us, yes, came after him. He punched him in the face, he got behind him, and he tried to choke him out. What does choke him out mean? Well, where's him? It means you're going to cut off the oxygen and the blood flow to the brain. And I asked him, can people die from that? Yes, they can. That would be murder. It was not. Only because the police came. We have no fingerprints from the defendant, either inside or outside the car. We have no fingerprints from the defendant on the weapon that was alleged here, this Diamondback 9mm. If somebody is trespassing on your property, you have a right to go to them and say, leave. You don't have a right to try and kill them. All right. Let's look at Mr. Denham's statement to the police officer, to Officer Alvarez, and also his statement that was made almost spontaneously while he's laying on the ground, handcuffed. His face is beat up, he's been choked, and he's trying to figure out why he's the one handcuffed on the ground. Yes, there was gunshot residue on his hand. There were 2 grains. And the lady that testified that she tested this sample found that there were 2 grains on that pad that was used all over his hand and arm on both sides. They found 2 grains. Well, what's a lot? Well, a lot would be over 10. She told us we cut it off to 10. That's enough. If you get 1, maybe you're in the area, doesn't mean you fired the gun. If you fired the gun, we have all of these exploding gases. We have 2 fires of the gun, 2 discharges. You get at least double that. It's not persuasive. Mr. Dedman's statement said, yes, the gun was fired there. Here's face and hand. That's how it got that very minimal amount of gunshot residue on it. They knew what Mr. Dedman had said at the scene and interrogation. There was never any attempt to check for gunshot residue on Cruz, on Mitchell, Cruz. Now, there's Jacqueline and Drew both testified that they saw the gun on the ground. And they saw Mr. Tovar come over and pick up the gun and take it away.
I'm going to object to the statement of the evidence.
I believe that is the evidence.
Well,
Right?
the jurors will remember the evidence as they've heard it. You may proceed.
Thank you, Your Honor. We'd like to check your memory. Think about that. That's what I recall hearing. They said they saw the gun. And yeah, it makes a better story. Mr. Tovar says, well, I had to put my hand on his wrist and took the gun from him. That's not what happened. Where do you hear that phrase again and again? When he was talking to Detective Alvarez. Detective Alvarez kept trying to get him to agree to a different version. And he kept saying, I know what happened. So just want you to understand that he does know what he was attacked.
Everyone, please make sure your phones are off.
It happened
Here are some
to me
results.
when my wife borrowed my phone over the weekend.
And then it happens to me.
I went into court and it wasn't on vibrate, and I was wondering who that first one was the judge was staring at. And I didn't want to turn around and see who it was. Then I realized there was somebody behind me. And my phone was going like crazy, and I have a hearing impairment, so I never even knew it was ringing. But that's a mistake that happened. There we go. All right. Jacqueline, she heard the shots. She is scared. She runs outside, calls Drew, calls 911. Says she saw the gun on the ground and told her to pick it up. Drew comes to the aid of his brother. I like to think that Drew did not know that his brother was quite literally trying to kill Mr. Dick. Trying to choke him out. And he joined him. He jumped on top, as he said. But he's not charged with using a knife and defending himself against these two men on top of him. He's charged with firing a firearm toward, or in a threatening manner, toward Michael Bruce. And I want to go full circle back to the discussion we had about beyond a reasonable doubt. Several different points where you have to hold up that template, see what comes through that sieve, if you will. Beyond a reasonable doubt means if you find that there is a reasonable, say, difference of opinion, that's reasonable. And that you cannot in your heart say that he definitely used a weapon, a firearm, in an illegal manner. Then I expect you to find out. Even if you decide, because all the evidence the prosecution put on, that he did indeed use it, then you must again apply that same beyond a reasonable doubt standard to whether or not he should be acquitted on self. We don't try to kill people because they walk on our lawn. There's no evidence other than Michael Cruz's statement that he was in the car. There's a lot of negative evidence that could corroborate it. We don't have the fingerprints. We don't have anything stolen. We don't have any evidence of breaking. And Kevin Deb now, what he was doing. He has a right to defend himself. And the prosecutor said, well, he had an obligation to retreat. He didn't have any chance of retreat. This guy came at him, punched him out, turned him around, and started choking him. You can't retreat from that. He was on the ground for over 30 minutes. And he is lucky to be alive. We ask you to find him not guilty. I do not get to answer the subsequent argument by the prosecution because they do have the burden of proof. And in recognition of that, they get to argue last. We appreciate your attention. Thank you very much.
State.
Thank you, Judge. So sometimes we have a tendency to overcomplicate things. Us as prosecutors, we have the burden of proving our case to you beyond a reasonable doubt. Because of that, we sometimes get hung up on the details, making sure that we bring our witnesses, making sure that we get evidence admitted. There's a lot of rules, and so sometimes we focus on that. Also, because we have the burden to disprove any defenses that the other side may come up with. So because of all of that, sometimes we forget what's important. We forget that the real important thing is the truth, the story of what happened. And so I want to start off with the story. We have the complainant, Michael Cruz. He testified that he's a father, he's a husband, he's a brother, he's his first family. On that night, April 27, 2019, he said they had come back from a birthday party and he was rushing because he wanted to catch the game. So he left the door unlocked. He goes outside later on because he's a father, he provides for his family. So he has a part-time job where he Ubers. It's dark outside, it's 11 something at night, and their driveway light is working. So he goes up to his vehicle, he opens the door, and he sees the defendant sitting on the left side of the car seat. And you can see in the picture that the car seat is in the center. So he testified that when he sees that, he runs around to the other side, doesn't close that door. And he's like, "Who are you? What are you doing in my car?" He pulls him out. This is the body cam video from Officer Garrett, who will arrive while Drew and Michael Cruz still had the defendant on the ground. They were holding him down. And you can see in this video, you can see the door is still open and the cabin lights are on, just like in this picture. So he sees the defendant. Defendant's dressed in all black, long sleeve clothing. It's April. It's hot. If you watch the video for Officer Garrett, you'll see that a lot of the officers are in like short sleeve shirts. Most of them are. For some reason, Mr. Devin was wearing all black on April evening. Defendant's version. So the defendant says that he's going to a bus stop. He decides to sit next to a tire of a vehicle to have a drink, and that he was never inside the vehicle. Inconsistencies with evidence. This was admitted, this is State's Exhibit 1. This was a map of the neighborhood. As you can see, that's the house right in the center. You see the bus stops up that street. There's been testimony that this was off of Paramount. That's Paramount. That's where the bus stops are. In order to get to the Cruz's house, you had to go away from Paramount up into a neighborhood and then make a right and go halfway down the street. But he says he was going to catch the bus. There were no beer sonnets. If he was drinking a beer right next to the vehicle, the officer would have found a beer right next to the vehicle or somewhere in the yard. There's no pictures, there's been no evidence that any goods were found, and it was never questioned. Common sense. Who decides to sit next to someone's vehicle in their driveway? I could see if the vehicle was parked on the street and he was like, okay, I'm just gonna rest against the vehicle. No, he walked up the driveway and supposedly sat next to the vehicle. That doesn't make sense. So let's continue with the story. Jacqueline Cruz, so Michael pulls him out, they start fighting. He testified that at some point he got behind the defendant, he had him in a chokehold from behind. He said while he had him in the chokehold from behind because the defendant was hunched over, he said at some point his arm comes up and he hears a shot go off near his face. He said his left side. And he admitted he did see the muzzle flash and he wouldn't because gun's up here. But he said the gun went off near his face. And so he said, then he starts to take him to the ground, trying to control his hand, and then the second shot is fired. And we know there was a second shot fired because the casing was stuck in the gun. So Jacqueline comes outside. She hears the gunshots. She runs outside to see what's going on. And she sees her husband firing. So she runs back inside and she gets Drew. She asks Drew to come outside to help her husband, help his brother. Drew comes outside. He doesn't put on any shoes. He just runs outside because he said he was winding down for the night. So he runs outside to help his brother. And at that point, he hops on top of them. They're trying to get the gun from him. The defendant pulls out a knife and stabs him in the leg. So let's look at the defendant's version. The defendant says that he's attacked out of nowhere. The first guy calls for a second guy. The second guy is the one who runs into the gun. The defendant sees the gun in the second guy's hand. And then the defendant bites the second guy on the hand holding the gun. And a shot is fired. Inconsistencies with the evidence. We have Michael Cruz's testimony, that's evidence. We have Jacqueline Cruz's testimony, that's evidence. And Drew Mitchell's testimony, that's evidence. Jacqueline and Drew said that, Jacqueline said that she didn't go inside to get Drew until after the gunshot was fired. So there's no way that Drew could have had the gun because he comes out after the fact. Let's listen to the defendant's version and tell me if you think this makes sense.
Just getting my ass choked and kicked and punched.
Okay, so at what point did you see the gun?
After he called for the other dude to come up.
Okay, gotcha. And then where where were you when you saw the gun, like as far as your body?
Man, I was on the, that's when I was swimming in grass on the,
So how were you able to fight the guy that had the gun?
and then,
Or how? If you're on the ground with your stomach on, you're on the ground, like on your stomach, how do you reach
because
over by?
they both like on me. Then when we had the thing, so I hold him, just like I said, like it's like, I'm on the ground, like this. The other one had his knee on me and choking me. He was doing some business shit, and that's why I seen that. Good.
And
That's when it popped.
that seems like an odd way to hold a gun towards somebody if they're on the ground and I can't imagine if you fucking stretch all the way up.
Because it went. No, I didn't stress. So I had to stress it. I was still on the ground. I seen.
And you had the gun almost on the ground.
It went up, like in the air.
But do you see how it doesn't make any sense? Like if you're face on the ground, I guess this guy has the gun and now he's pointing it this way. So I would say that he's like this. That's a weird way to hold a gun towards someone.
I don't know. I mean, all I know is that I seen it, and that was it. Now what?
The defendant. He realizes he saw, I don't know. I just know I seen it and that was it. It doesn't make any sense. 9602 Hillsborough Drive. This is Drew. As you can see, he's not wearing shoes because he ran outside barefoot. Next, we have testimony from Michael Tovar. Michael testified that he heard gunshots, sounded like it was close to his house. So he goes outside. He can't see anything, so he runs back inside, puts on some shoes, and grabs the flashlight. You can see him holding the flashlight here. He then testified that he saw his neighbors, who he didn't know them, he didn't know their names at the time. As of now, all he knows is that Michael is the person who our complainant. So he sees them fighting on the ground. They're telling him that the defendant has a gun. So he runs over, he sees the gun in the defendant's right hand, he steps on it and takes the gun from his hand and takes it and puts it on his porch. Now, Mr. Young had a chance to cross Michael Tovar. He didn't ask him about, oh, well, you didn't really take the gun from his hand, did you? No, because it's the truth. It's consistent with what he said at the scene. It's consistent with all the witnesses said at the scene. Defendant's version. Defendant didn't produce the gun, never had the gun, and he doesn't remember the neighbor being involved. Inconsistency with evidence, again, Michael Cruz's testimony, Drew's testimony, and Michael Tobar's testimony. They all put the gun in his hand. It's also inconsistent with Christina Bushong's testimony. She was the one who did the GSR testing. She testified that the GSR was found on the defendant's right hand. None was found on the left hand, which is consistent. He was holding the gun in his right hand when Michael took it from him. He had GSR on that hand. Mr. Young got up here and he said something about, oh, 2 shots fired, double GSR and things like that. And Christina testified, there's no exact way of knowing how much GSR there was. And if he wanted to ask her that question about should there be double, he could have, but again, he didn't, because he knows what the answer is. Other evidence that we have. Now, this case is a little unusual because usually when we have a gun, we just have a gun. But in this situation, we have a gun that actually came back to someone. So the Diamondback 9mm that was found in the defendant's hand, according to Michael, according to Drew, and according to Michael Tobar. Where did it come from? It was taken from Brandon Grass' vehicle. And he testified to that. He came and told you about that yesterday. He was like, yes, I had a gun. The Detective Ferguson, came to see me. I wanted to check for my gun, and it was no longer. Other evidence. The Grass credit report. Mary Graff's credit card. Where was that found? That was found on defendant's person in his wallet, along with State's Exhibit 37, which is a piece of paper with his name. Where was it taken from?
What is the next?
Where was it taken from? It was taken from Brandon Graff. Lastly, the Monarch ammunition. Brandon Graff also testified that he had a box of ammo, that same ammo in his car, and it was no longer there. Where was this found? It was found in the backpack that defendant had on his person at the time that Cruz saw him in the vehicle, and he still had on him when the officers came. Where did it come from? This vehicle. So in Wardar, I talked to you about the elements, and I told you it's just how we break down the law to make sure that we prove everything that we need to prove. In Wardar, I talked generally on or about a certain date in Bexar County, Texas, the defendant intentionally or knowingly threatens another with imminent bodily injury and uses or exhibits a deadly weapon during the commission of the assault. And how he did it. So now applying that to the facts of this case, on or about April 27, 2019, in Bexar County, Texas, the defendant, Kevin Devlin, intentionally or knowingly threatened Michael Cruz with imminent bodily injury. He used or exhibited a firearm, and he shot at and in the direction of Michael Cruz. So the first 3 things, there's no dispute that it was April 27, 2019. No dispute that it was in Bexar County, Texas. No dispute that it was. Everything is over whether the defendant had the gun. The evidence that you can consider when you go back there, testimony of all the witnesses. There were 11 witnesses that we brought to you. You can consider the 911 call that was made by Jacqueline Cruz. You can consider Officer Garrett's body cam video. You can consider the defendant's interview. Also, there's the physical evidence, the GSR kit, the gun, the knife, all of that. So Tom covered this, so there's no need for me to really go over it again, but Mr. Cruz had a right to defend his property. He testified that he didn't go out into the street and grab Kevin Devlin and pull him on his property, that the defendant was on his property, and that's consistent with that. Even Kevin admitted that he was on the property. Mr. Cruz doesn't get self-defense. As Tom went over, it wasn't in response to an unlawful action. and it wasn't reasonable. It's not reasonable for someone to, for example, for me to attack Tom, he tries to attack me back, and then I shoot him and say that's self-defense. It's not reasonable for me to break into Tom's house. He tries to protect his property, and then I shoot him and say that was self-defense. That's not self-defense. So I'm gonna play Jacqueline Cruz's call for you that she made while everything was still going on.
No, don't let him go. I need a police. Right now, I have somebody in my front yard. They were trying to, I don't know what they were trying to do, break into my husband's car or something. What's the address? 9602 Hillsborough Drive. San Antonio.
Okay, are there any weapons involved?
Yes, they shot at my husband. He shot at my husband.
Okay, is he hit your husband?
No.
Your husband was not
He's
hit, okay?
fucking shot my brother-in-law.
Yeah, okay?
What the fuck? You just go inside me. Go inside me. Go inside.
How many shots?
Go inside. Two shots.
Okay. Take a deep breath with me, okay? They're heading out there right now, okay? Stay on the line with me. What is your name? What is your name?
My name is Jackie.
Jackie what?
Yeah, going cruise.
Jackie, okay. And do you have the people there?
My husband and my brother-in-law are holding him down on the ground. He was sitting in our car.
Is he a
My
black,
husband-
okay, is he a black, white, or Hispanic male?
Black.
Black male, what is he wearing?
I don't know. They're both laying on top of him. He had a knife and a gun. He tried to. Please hurry.
Yes, they're heading out there, okay? So nobody's hurt, you don't need to use this, right?
My brother-in-law is stabbed. He stabbed my brother-in-law. I don't know if my husband's okay. Just like in my bed.
I'm sending you myself there too, okay? What is your husband's name?
It's a gun. My husband's name is Mike.
Where's the gun right now?
My neighbor has it. He just found it on the ground.
Your husband's name is Mike Cruz?
Yes.
What's your brother-in-law's name?
Andrew Mitchell. Hold on, baby. You're right there. It's okay.
The suspect is still on ground?
Yes, he's still on the ground. They're holding him down. But he's trying to get up.
Where's the knife?
I have it. Oh my God.
They're on their way out there, okay?
I guess my husband's coming outside to leave to go Uber. And I guess this guy was shooting in his car. So I was laying in the bed and I heard two gunshots and I ran outside.
So he was trying to break into the car?
He was in our car.
Okay.
They're coming. They're on the way.
And so he shot the two rounds at your husband and then stabbed your brother-in-law?
Yes.
Where is he?
I think the way.
And then your brother-in-law's on top of the individual?
Yes, they both are.
Down the line. It's the 9602 Hillsborough Drive. I have the female on the line for brother-in-law was stabbed in the leg it started off as a shooting in progress and then she was stabbed.
Okay. Listen, we got help on the way. Are you next to the person who got stabbed?
Yes. He's right here. He's here. Go inside.
Okay, put pressure with something clean. A towel or a shirt.
Let me go.
He's awake and breathing?
Yes. They're both holding the guy down on the ground.
All right.
My baby is okay.
Continue to hold pressure until we get there, okay?
Okay.
Keep passes out or stops breathing before we get there, just call us back. Police, fire, and EMS are on the way.
Okay.
I'm still on the line with you, okay?
Okay.
They should be pulling up here any moment. They're on current vital right now. They're a few blocks away. They're pulling up here. Just a few moments. Okay?
He said they're about to pull us right now. Yeah, they're coming. They're gonna be here. He's here.
2 minutes.
No.
All right, where's he at now?
He's still on the ground. There you are right there.
Is he breathing?
Yes, he's breathing.
Okay,
He's just out of the leg.
okay, just continue to hold pressure until we get there.
He's holding the guy down. He won't hold any further on his leg. There he is right here.
All right, I'm gonna hang up now.
Okay.
Yeah, the officers are there.
So that's real. That's the truth. You can hear it in her voice, you can feel it. So we've proven this case to you beyond a reasonable doubt. And so like Tom said, we're asking that you hold the defendant accountable for his actions, for his choices, for them.
All right, ladies and gentlemen of the jury, you have all the evidence before you, and now you have my permission to deliberate. The deputy will take you to the back of the jury room. All right, and if I could have the two alternates please remain in the courtroom. Everyone, please rise.
Judge, Dalton's like,
No, the alternates.
oh, the
Yes.
alternate.
Yes. All right, everyone, please be seated.
That was
No,
my next
people
question.
always-
What are we gonna do with the alternates?
Yes. All right, everyone, I want to remind everyone that we are live. So I'm going to take this opportunity to speak with the alternates. After I speak with the alternates, then if counsel for the state and the defense, if you all would like to speak to the alternates, and if they would like to speak to you, I will allow that. So we're going to take a brief recess, everyone. And if you all will wait for me right outside this door, please.
Well,
All right, everyone, you're in the 187th District Court. Whatever physically in the courtroom, you cannot do here. I'm going to open the breakout rooms. Do not go to a breakout room unless I specifically assign you to a breakout room.
Dr. Coordinator's going to tell him to come back right now.
All right, so this is what I'm going to do. I'm sending everyone to a breakout room. We have a verdict in another case. So Ms. Ferguson,
Yes, ma'am.
I'm going to send all the inmates to breakout room number 1. Could you go there with them, please? So there will be no issues.
Yes, ma'am.
And then once I deliver the verdict to the defendant, then I'll bring them out of the breakout room.
Of course. Yes, ma'am.
And to the clerk, I'll send you to number 1 as well. Mr. Hernandez, I need you to go to the breakout room. And everyone else, if you could stop your video, please. Mr. Perez, if you could stop your video, please. Jorge Canales, if you could stop your video for me, please. Yeah, I'm gonna have to remove him. I'll bring him back though.
Judge, did you see the CCA issued in addition, decision on Q?
No, I have not reviewed it yet.
Reverse. It was a res geste statement.
So what?
Did I not say?
We just talked about it last night. A different case. Remember, we hear when the judge was talking about a case called Pew last night. It's a res geste statement in the back of a cop car. Okay. Basically, the guys, they say, do you want to tow your car? You want your wife to come
Yes,
pick it
we're
up?
ready.
He's in custody. He's in the back for murder warrant. He's like, my wife can come pick it up. Cool. So they're sitting there waiting. And then after a while, the guy's like, I got some stuff in the car, some drugs and stuff. And then based on that res geste statement, they go and search a car and leads to this. And so they had gone and they had put that case on in punishment.
Yes.
Okay, they put that case on in punishment. And the judge had allowed the statement as a res geste. And the fourth court had said, no, it was an unmirandized interview solicitation. And that decision had reached the CCA, and the CCA said today, no, it was a res geste statement.
It was.
Well. You know, I try my best to always get it right.
Brenna, I don't even know if it's going to be a jar anymore. I mean,
Yes.
Okay, they're gonna read it. The judge will probably be the one that stand.
Everyone, please be seated. Ladies and gentlemen of the jury, it's the court's understanding is that you've reached a unanimous verdict. Is that correct? All right, Deputy, if you could hand me the verdict form, please. All right, the verdict form appears to be in proper order. If the defendant could please rise. And cause number 2019 CR 6484. According to the verdict form, it states, we, the jury, find the defendant, Kevin Dabnab Jr., guilty of aggravated assault with a deadly weapon as charged in the indictment. You may be seated, Mr. Dabnab. Does anyone wish to have the jury polled?
Yes, Your Honor.
All
Defend.
right. Ladies and gentlemen of the jury, I'm going to ask each one of you if this is your verdict. If it is your verdict, I will need you to say yes. Does everyone understand? So what we'll do is we'll start here. Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? All right, ladies and gentlemen of the jury, thank you so much for your service. I'm going to send you back to the jury room, and if you will wait for me there, I'll excuse you from there. Everyone, please rise. All right, please be seated. Mr. Dabnab, it's the court's understanding and your choice was to come to the court for punishment. What will happen is the court will receive a report. It's called a PSI report. The court will receive that. At that time, the court will base its decision on punishment based upon that report I received and any other evidence that's presented. Is there any questions from either side?
Judge, the state would request that the defendant be remanded without bond pending sentencing.
Defense?
Your Honor, Mr. Debnap has been in custody for a very, very, very long time. I would ask that the court not remand him without bond, and that if he does decide to bond out, that it would be available to him.
All right, well, the court is going to grant the state's motion. The court will remand Mr. Dabnap without bond. However, the court will reset the issue. If you wish to have a hearing where evidence is presented on the remand without bond, the court will hear that at that time. But for now, your client is remanded without bond. And if you will let the court what date you would like it set to hear the formal motion for remanding without bond, the court will hear that.
Your Honor, I will have to discuss with Mr. Debnap if we have any evidence that we can present to that effect.
Okay. If you want it in 7 days, the court can have it in 7 days.
I'd like to talk to my client at some point, Your Honor. Not today, but as I'll go to jail and talk to him.
All right. And if you can make sure you confer with the state and if you can confer with the defense on what date to present evidence for the remand without bond.
Very well, Your Honor.
And everyone, just give me a moment. Let me check with the court coordinator on what date we will come back for sentencing. Norma? Just one moment. Thank you. All right, we're back on the record in 2019 CR 6484. Mr. Debnab, your sentencing date will be set for July 7th at 9 a.m. Defense, are you requesting any type of TAP evaluation of anything of that nature? Mr. Young?
I'm sorry, Your Honor, what?
That's okay. Are you requesting a TAP evaluation or no?
Yes, Your Honor.
Any other type of evaluations?
No, Your Honor.
All right, then, Mr. Debnab, we'll bring you back on July 7th at 9 a.m. for sentencing. And of course, defense, if you want to have formally heard and present witness with regards to the remand without bond, just let the court know when you wish to have that done. Do you need to speak with your client anymore, Mr. Young?
No, Your Honor.
All right, Deputy, if you could take Mr. Debnab back, please.
I don't know. Like it's the battery died? What? Was it also? I thought you put that one in the front.
All right. If everyone will just give me a moment.
But sure didn't put it in the front?
And if you could mute us, please.
Well, despite what they
Okay, all right, we're back. Hey, I appreciate it. All right, let me call you back. Okay, bye. All right, is everyone able to hear me?
Yes.
Yes.
All right, thank you. So what I'm gonna do is I'm going to open up the breakout rooms. Do not, I repeat, do not go to a breakout room unless I specifically call you by your name and assign you. And let me make the prosecutor's co-host. And Raymond Martinez, you're in court. Okay, all right, just give me a moment with that. Okay, just one moment, I will get to you, I promise. All right, everyone, this is the 187 District Court. I know some of you are Zooming as opposed to being in person. You must remember that this is a courtroom. Anything that you could not do if you were in the courtroom, you cannot do on Zoom screen. Breakout rooms have been created to all of the persons who are inmates. You're not allowed to use the chat box. If you use the chat box, you will be sent back. You're also not allowed to use the chat box to try to pick up dates. If you do that, you will be sent back as well. And please make sure you are on mute. I'm going to call the attorney's names, and this is the order in which you will appear. I have Keith Engelke, Adrian Perez, Raymond Martinez, Nifa Carrillo, Adam LaHood, H. Dave Sanchez, Jorge Canales, Michael Latimer. Is there any defense attorney's name that I've missed or have not called?
Yes, Judge. Rolando Arguelles.
Rolando Arguelles.
Yes, Judge.
Yes, okay, I'm not gonna take 100% credit for that. Raymond Martinez was off screen and he was telling me how to pronounce it. The double L's get me every time. All right, and Joseph Stateson.
Yeah, thank you, Judge.
All right, anyone else? Okay, let me make sure prosecutors are all co-hosts. All right, attorneys, when I call your name, if you could let me know if your case is criminal trial division or family violence in the name of your client, please. Keith Engelke.
I believe it's criminal trial, Your Honor.
I'm sorry, who?
I believe it's criminal trial. My client is Adam Hernandez.
All right, I'm going to send you to breakout room number 2.
Thank you.
So did you join the meeting room? Go back in front of the judge? Judge, he needs to go for paperwork with his client. Judge.
All right, Mr. Hernandez, Norma, if you could have a deputy send him to number 2, please. Mr. Hernandez does not know how to work the screen.
No, it's Adam Garza, Judge. He's L16, and I'll see where he's at.
All right, I'll send him to number 2. All right, and Norma, if you could go back to breakout room number 1. For some reason, Kelly and Vasquez, 2 inmates are in there together by themselves. Could you go in there and pull them out, please?
Yes, ma'am.
Thank you. Adrian Perez.
Good morning, Judge. I have Eli Cantu. This is actually a sentencing with criminal trial. Tom Nisbet was the last prosecutor I worked with. Probation is telling me that they need additional time for an evaluation. I'll let probation speak to that, but I'd like to reset a sentence and if some evaluations that you ordered are still outstanding.
All right, just give me a moment. Raymond Martinez, who do you have? All right, who was the prosecutor on Andy Aborto? Was that Meredith McIntyre? It's from June 1st. I don't believe it was her.
No, Your Honor. I was doing Adam Garza paperwork.
All right, no problem. Hunter?
Yes, Judge.
I'm being told by Raymond Martinez, his client was to turn himself in to go into inpatient treatment. He's already pled true to violation of condition number 5.
Okay.
Are you aware of that?
I don't immediately recall it, Judge, but I don't claim to say that didn't happen.
Okay, I believe it's defense counsel is telling me it's actually Tom Nesbitt. So just give us a moment. Tom is going to zoom back in. All right, Nifa Carrillo. Yes, who's your client?
Yes, I'm Guadalupe Cáceres, John. I'm a PSI.
All right, just give me one moment.
Yes, sir.
Adam LaHood.
Yes, Your Honor. I have William Condra, and we have filed a motion requesting a competency examination.
All right, William who?
William Condra, Kandra.
All right, Norma, do you have a copy of a competency motion for Mr. Condra? We're going to find out. Just give us a moment.
Yes, ma'am.
And Deputy Laura, I'm receiving feedback from the state's computer. So I think what's going to end up happening is I'm going to take my computer back in chambers. Everyone, resituate myself to chambers so that I won't get feedback from everyone. So just give me a moment and let me admit.
Barely, barely.
All right, everyone. Yay, Brenna, I feel different since I'm back in chambers. I can move around more. All right, Adam LaHood, your client, what's his name again, please?
William Condra, Kandra.
All right, we're going to recall your case for July 19th.
July 19th. Your Honor, do we need to get a referral to Mag Court for the competency?
What will happen is the court coordinator, if you don't have any objections, she's going to file the competency request.
Yes, ma'am.
And hopefully it will be expedited.
I appreciate it. July 19th. We'll hopefully
Yes.
have it back by then. Thank you.
You're welcome. You're excused.
Thank you, Your Honor.
Should I take one?
All right, and then the next person is Adrian Perez on Eli Cantu.
Yes, Your Honor.
You
He
said
said
there's an issue.
Yes, I'll let probation speak to that. I received his PSI today. Probation said there's an additional evaluation still outstanding. And I just spoke to the probation officer by Ms. Reyes.
Yes, I was trying to unmute my button. The PSI and TAP have been completed and the mental health evaluation have been completed. The mental health evaluation requested further Tacoma evaluation, which is set for the week of July 22nd.
All right, Norma, can you give them a date after July 22nd?
And they'll need about a week.
So a week after that, please.
We can come back on August 2nd, Judge.
Your Honor, I have a vacation letter for that week. I could do the 9th.
All right,
No.
Norma, is the 9th okay?
Yes, ma'am, that's fine.
All right, so we'll set it for August 9th at 9 a.m.
Judge, give me 1 second, Judge. Give me 1 second. Let me. We might be in trial that day, Judge. I would have to do it. The 16th. We can come back on the 16th, Judge.
All right, so we will put you down for August 16th.
Honor, may I be excused?
Yes.
Thank you.
All right, is Tom Nesbitt here?
We're asking for him to get on, Judge.
All right, thank you. Thank you, sir. Everyone, just give me a moment, please. All right, Tom, Raymond Martinez is telling me that you were the prosecutor who was on his case involving.
Judge, can you give me like 2 minutes?
Yes.
Got my computer plugged in upstairs, nothing's working, and I can't get the docket, so I gotta
Okay,
fix
all right, no
this and-
problem.
Thank you.
All right, H. David Sanchez, who do you have? You're muted.
Tydell Wardy, and it's a pretrial diversion.
Judge, I do know on that one, I know he's accepted and I signed it myself yesterday.
Okay. Norma, when does it need to come back then?
I signed the dismissal for it. I think he's on. He's done all the contract and everything too. I think that one is completed.
Okay.
Give me just a few minutes, Judge.
All right, thank you.
I just sent you a chat, Judge.
Okay. All right, tell them he will be there and.
Yes, that's what I told them.
Yeah, all right, thanks. All right, Jorge Canales.
Why is it not working?
Judge, I have Angelina Macias, the PSI, but I have to approach Judge on the fact that I got some recent information Monday, but as a matter of fact, from her mother, which I think we have to do a competency evaluation, Judge, just like the previous case that you had. This is all new to me. I'm reading the PSI. I have no knowledge of all these factors, mental health factors, that she has been on medication since she was 15. I didn't know any of this. I would have asked for a competency evaluation at that time if I did.
Okay.
So if we could recall it and give me time for it, I think that would be the best route for this case.
Just 1 second. All right, Norma, on Miss Macias, is there any way we can call her back on July 19th as well for competency?
Yes, ma'am.
All right, we'll call you back on July 19th.
Judge, and would that be taken care of by the coordinator also?
Yes, and everyone, just give me a moment, please.
Oh.
Judge, I also wanted to let you know on this case, also, they're waiting for the Tacoma evaluation. And that's, hers is scheduled the week of July 17th.
Okay, Norma, then we need to put it later than July 19th. Do we want to put it on the same date as the other one?
Yeah, the August 16th.
Yes.
Yes, sir.
Our mouse flipping work anymore?
Okay. All right, Jorge,
Yes, Judge.
we're going to bring you back on August 16th.
August 16th. That'll be fine, Judge.
All right, Ms. Macias, we'll bring you back on August 16th.
And Judge, I send you a chat as well.
All right, thank you.
And Your Honor, may I be excused?
Yes, you may be excused.
Thank
All
you.
right, the attorney on Tydell Wardy, you are excused.
Okay, Judge, thank you.
Thank you. Michael Latimer.
Good morning, Judge Boyd. I'm on Homero Vasquez Tellez. He's got 2 cases in criminal trial, a division, and 1 case in family violence.
How do you spell the last name?
Vasquez, V-A-S-Q-U-E-Z hyphen T-E-L-L-E-Z.
All right, I'm going to send you to breakout room number 3, and a prosecutor will meet you there.
All right, thank you.
Rolando Arguelles. I know I mispronounced it. I'm sorry.
Nah, no, fine. I'm here. It's criminal trial division judge, and I'm here representing Ms. Rosano. She FTA'd last time we were in court. There's a PTD offer extended to us. I need to review it with her so she can fill out the PTD application. We can submit it to the court. But I was gonna ask the judge if we can potentially get her back on bond conditions or get her back on bond.
I'll send you to a breakout room to confer with the state on that matter.
Yes, Judge. Thank you.
I'll send you to breakout room number 4.
Thank you, Judge.
You're welcome. Joseph Stateson.
Good morning, Your Honor. The attorney of record on this one is Joanne de Hoyos.
Yes.
And George Kelly, we're just waiting to see, did he hire someone? He said he was going to. We've been waiting since Friday and then Monday, and it was recalled again today.
All right. Norma, Mr. Kelly, can you unmute yourself, please?
Yes, ma'am.
Do you have an attorney?
Not yet. I need more time to pay my attorney.
Yes. Your attorney is Joanne de Hoyos.
Right, but
Mr. Stetson, I'll send you to a breakout room to confer. Mr. Kelly, we're not going to wait forever for you to have an attorney. Until you have an attorney, your attorney is Joanne de Hoyos.
Can I get Can I get a new state appointed counsel then, please?
This is what I'm going to explain to you. You don't get to choose who your attorney is. Your attorneys are on the will, and the attorney that comes up, that's your attorney. So let me just tell you this. I've been a defense attorney. I've been a prosecutor. Your attorney will receive an offer from the state because I require the state to tender an offer to your attorney. Whether or not you accept that offer is completely up to you. Your attorney cannot force the state to give an offer that maybe you want. I don't know what is happening with your negotiations, but where we are now is Joanne de Hoyos is your attorney. I'm sending them to a breakout room, number 5. They're going to confer with the state. If you want a new attorney, then you will need to hire one.
Yes, ma'am.
All right, you're welcome. Okay. And then Keith Engelke, you're on Adam Hernandez.
Correct, Your Honor. I've spoken with him and he's accepted the state's offer. So we just need to get, I've signed the paperwork and we need to get him the paperwork to sign.
Okay, we will make that happen.
Great.
Just give me a moment. And Raymond Martinez, we will be with you shortly. And
I'll join in the breakout room. My client.
no. Yes, Mr. Engelke, if you'll go back to breakout room number 2, you'll receive your paperwork.
Thank you.
You're welcome. All right, Brenda, is Raymond Martinez still in the courtroom or no?
He stepped out, Judge.
Okay. Nifa Carrillo.
Yes, Your Honor.
All right, who is your client?
Guadalupe Cáceres.
All right, and this is for sentencing. State, are you all ready? Who will be the prosecutor handling this?
Judge, I could stand in. Can you tell me what the stiff page says?
Yes, it's a cap of 5 and the state is silent.
Okay, yeah, so.
Tom, I'll stand in for it. I helped out.
Okay.
Sorry.
All right, the court is calling 2020 CR 11345, State of Texas versus Guadalupe Cáceres. Could I have parties announced for the record, please, for the state?
Morris for the state.
For the defense?
Infagallos Carrillo for Mr. Cáceres.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
All right, the court will note for the record that the defendant entered his plea by video on April 27, April 28, 2021. The defendant pled to count 1 only. The state waived and abandoned the habitual enhancement without objection. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There is no fine, and the state is silent on the defendant's application. And the defendant has applied for regular probation. Have both parties had a chance to review the PSI report?
Yes,
Yes,
Judge.
Your Honor.
Any objections to the PSI report? State?
None from the state.
Defense?
No, Your Honor.
All right, defense, the state is silent. You may proceed.
Your Honor, what we have here is Mr. Cáceres. And of course, you've seen the PSI, and he has a criminal history which resulted in an habitual indictment. But you also can see that he has, the last time he was out of parole was in 1997. There has never been anything, any activity, any criminal activity. In fact, he put his life back together. He's been married over 40 years, 50 years to his wife. They have 2 children. He has, he's a truck driver, and there's nothing there to show that that he has engaged in this kind of behavior. Now, also, I'm sure that you read in there that my client has minimized the guilt, but it's not minimizing because he's being truthful. Now, he's always told me right from the beginning, I don't know where I got, from what source I got that money. However, it is possession. He says, I did have it. And so he's taking responsibility for it. And, you know, he has a good support system at home. He has his children, his daughters, and his wife, who he takes care of. and a job that he's still at it. And so we asked the court to grant his probation. The money has been repaid, whatever it is, the reimbursed to the complainant. And again, like I said, there's nothing there that's leading up to this that explains this behavior. And the place that he went to, that he gave the $20 bill, he's there all the time. They know him. And he was there when the police came over. And now if he was passing counterfeit, then he would have taken off. However, because he had an habitual, he was concerned that in a jury trial, if he is found guilty, then he was facing a long prison term, minimum prison. And that made him decide to plead and take responsibility, because he did have possession of those bills.
All right, Mr. Casares, is there anything you wish to say?
No, ma'am.
Where are you working?
I'm a truck driver for David Martinez Construction.
Are you still gambling or no?
No, ma'am.
If you're given a drug test today, what are the results going to be?
Negative.
All right, this is what the court will do. Court will grant your application, sentence you to 4 years in prison, suspended and probated for 4 years. Are you able to report by Zoom?
Yes, ma'am.
All right, there's to be regular reporting by Zoom or in person. So if there's an issue with you reporting by Zoom, you are to do it in person. Do you understand?
Yes, ma'am.
There's to be regular UAs, 100 hours of community service restitution, or you can pay $7.25 per hour to the San Antonio Food Bank. Proof of employment within 15 days. No employment with vulnerable people. What that means is you can't be a home healthcare provider or have any occupation that involves the supervisions of minors. Do you understand?
Yes, ma'am.
Rebecca, is there any?
Wheeler, Your Honor.
I'm sorry, yes?
Drives an 18-wheeler, so
Okay.
that's his nature of work.
Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Casares, is there anything that you need from the court in order to be successful in this probation?
No, ma'am.
All right, next I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also, because this is a felony conviction, you are not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Casares, good luck to you. I'm going to send you to a breakout room so that probation can go over conditions with you.
Thank you. ma'am.
Courtroom, I'm going to send you to breakout room number 1.
Yes, Judge.
May I be excused, Your Honor?
Yes. And Rebecca, if you could go to 1. And everyone, just let me sign some paperwork.
Good morning.
All right, and let's see. To the clerks, I'm going to send you to breakout room number 2 to swear in someone, please.
Thank you, Judge.
You're welcome. And is there anyone else? Raymond Martinez, you're here? Tom Nesbitt?
Yes, Judge.
Raymond Martinez says that you were the person who negotiated the agreement with him on his client Mr. Andy Alberto. It was for him to go into inpatient treatment.
Actually, Judge, we were just following probation's recommendations, my recollection.
Both of those are one and the same thing. And yes,
All right, and where was he supposed to go?
state ISF, cognitive and substance abuse track.
All right, could I see Mr. Andy Alberto?
Close enough, Judge.
All right, thank you. I needed you because Rolando came back in and I couldn't remember what to do with the double L's. All right, the court is calling 2016 CR 3597B, State of Texas versus Andy Alberto. Could I have parties announced for the record, please, for the state,
Tom Nisbet.
for the defense?
Raymond Martinez.
We're proceeding by video because of the pandemic. Any objection from the state?
No.
Any objections from the defense?
No, Your Honor.
And the court will note for the record that on July 1st, the defendant entered a plea of true to violation of condition number 5, and that was taken by video as well. Mr. Alberto, do you have any problem with this proceeding by video?
Oh, ma'am.
And the court will note for the record that the defendant is in the courtroom, and this is one of the days the court is allowed to have in-person hearings. The court found violation of condition number 5 true. The defendant had asked for time to report in court. The court gave the defendant that time. The court will deny the motion, alter and amend conditions to include ISF, substantive and cognitive track. Is there anything else from either side?
There's a few more conditions from probation judge. It's to, and then to restart ISP for 1 year. Complete his theft class. They're recommending a curfew from 7 p.m. to 7 a.m. for 6 months. And documented weekly sober support meetings.
All right, defense, was that the agreement?
Yes, Your Honor.
All right, then the court will order that you attend ISF substantive and cognitive track. You'll be taken into custody today to start that. When you're released, you're to restart ISP for 1 year. You're to complete the theft class. Your curfew is 7 p.m. to 7 a.m. Basically, you need to be home when the lights come on outside. You understand?
Yes, ma'am.
That's for 6 months. And you're to start documented weekly sober meetings. Do you understand?
Yes, ma'am.
All right, Mr. Alberto, is there anything else that you need that I haven't addressed that you feel will help you be successful on this probation?
Am I going to any classes after ISF?
You're going to be doing the weekly sober classes. Here's the thing, you know yourself better than I know you. I dare to say you even know yourself better than your attorney knows you. Whatever you need in order to be clean and sober, that's what you need to do. So they're saying they want weekly sober meetings. If you feel like you need meetings 2 times a week, then do it 2 times a week. That's not going to interfere or force you to be longer on probation. As a matter of fact, it's showing me that you know what you need to do in order to remain clean and sober.
Yes, ma'am.
From here on out, though, you need to start asking yourself, is the decision I'm making could result in me going to prison? That should be your question for everything that you do from here on out. You understand?
Yes, ma'am.
All right. Do you have any questions? Any more questions?
I don't.
All right. Good luck to you. If I didn't think you could be successful at this, I would have revoked you. Because guess what? I don't have to follow any agreement that's reached between your attorney and the state. You understand?
Yes, ma'am.
So I know you can do this. You just have to want to do it. All right, we'll close the record on that. Thank you, Mr. Martinez. And County Court at Law number 1 was looking for you, but
Yes,
the
I
court coordinator let them know where you were.
Thank you, Judge.
All right, thank you.
And excuse me, Judge, I have an announcement for the court whenever the court's ready.
Yes, we're ready.
I conferred with Mr. Saunders, Judge, and we have come to an agreement to have Ms. Rosano released on PR bond with conditions of GPS monitoring so she can do the PTD application in this case.
Okay, let me ask you all this. Does anyone know what her criminal history is? Does she have any criminal history that would exclude her from receiving a PR bond?
I do not, Judge, but I can double check on the Bexar County Court Records website and see what I can pull up on my end.
All right, but I would need like the out of counties as well.
I do not have access to that, Judge, as far as I.
Can you hear me, sir?
Yes, ma'am.
Okay. I don't have any records. I have one charge like 2014 and like nothing else. I've been under the radar.
Okay, Miss Vanessa Rosano.
Yes, ma'am.
I hope you understand why I say that we need documentation.
Oh, okay, I understand. Like I said, I've been here. I don't know. I'm not familiar with the process.
All right, well, the reason why you're at the Bexar County Jail is because you didn't show up for court.
3 days prior to that, my phone got wet and my photo, my
Time out, because your attorney probably doesn't want you to say certain things. So just give us a moment.
And Judge, I just looked at the court records website. It seems that there's a case from 2014 for prostitution that was closed, and the current case that we are on right now, which is the theft of the aluminum, bronze, copper, or brass.
All right, if State Defense, if you will send me an email, then I will grant your motion.
Okay, and Your Honor, might be put in a breakout room with my client to let her know what's going on and then be excused, Judge.
Yes, but before you go, Norma, can you give them a 30-day reset for PTD, please?
And I'll be sending the order shortly, Judge. Do you want me to email it to Ms. Ferguson?
No, if you can include the state and yourself in the email to me.
Oh, yes, Judge.
All right. And Norma, what day do you want Ms. Rosano back?
She can come back on the 13th of July.
All right, we're going to go on the record. Court is calling 2021 CR 1907 State of Texas versus Vanessa Rosano. Can I have parties announced for the record for the state? Oh, Meredith, you're muted.
Meredith McIntyre for the state.
For the defense?
Landor Ways for the defense.
All right, Ms. Rosano, can you unmute for me, please?
Hey.
All right. Now, my understanding off the record, and State Defense, correct me if I'm wrong, is that they're allowing you to apply for pretrial diversion. Is that correct, State?
Yes, Your Honor.
Defense, is that correct?
That is correct, yes, Judge.
You are to come back on July 13th. Do you understand that?
You're muted, Ms. Rosano.
Okay, can you hear me?
Yes.
Yes, ma'am.
Okay. Yes, ma'am.
You understand you are supposed to be in court on July 13th. Do you understand?
Yes, ma'am.
You can appear by Zoom or you can appear in person. Do you understand? And it is at 9 a.m.
Yes, ma'am.
Do you understand?
Yes, ma'am.
And it is the 187 District Court. Do you understand?
Yes, ma'am.
So what date are you to appear by Zoom or either in court?
August 13th.
I'm sorry, what?
13th.
Of what month? July 13th. All right, Ms. Rosano, what date are you to appear either by Zoom or in court for your next hearing?
July 13th next month. July 13th next month.
What time?
I am 187 court by Zoom or by court.
And what's going to happen if you do not appear?
I will be put back in this place.
All right, we're going to bring you back on July 13th at 9 a.m. Make sure you're here, okay? All right, if there's nothing else, You are excused. Norma, can you let them know that L20 can go back after her attorney speaks to her?
Thank you, Judge. I'll see you soon.
All right, and Mr. Arguez,
Arguez. There we go.
could you make sure that you have all of her information to contact her, please? I know you will.
Yes, Judge.
All right, so if you'll go back to breakout room number 4,
Yes,
and
Judge.
when you finish speaking to your client, bring her back to the main room so we can have her excused.
Yes, Judge. Thank you.
You're welcome. All right, Joseph Stateson?
I'm still waiting in room 5. I switched devices. Could you
All
put,
right.
I'm on my laptop. If I could go into room 5 and I'll disconnect my iPhone.
Okay. And could someone join Mr. Stateson in 5? It's criminal trial division on Kelly.
Yes, Judge.
All right, Michael Latimer.
Yes, good morning, Your Honor. I spoke to Mr. Morris. We have an offer on all 3 cases for 30 days, but I would like to speak to my client if he's online or not.
Is your client on bond or in custody?
He's in custody, or at least as far as I know he is. It's Vasquez Tellez.
All right, Mom, Norma, can you see where Vasquez Tellez is, please?
Okay,
Yes, ma'am.
no.
Thank you. And who are the parties on Adam Nathaniel Garza, please?
Meredith McIntyre for the state.
Ruth Engelke for the defense.
All right, and Mr. Engelke, if you could for me, if you could back away a little from your microphone.
Is that better?
Brenna, is that better? We shall see. Oh, I'm sorry, Brenna, you're on mute.
Okay, can you hear me now?
Yes.
Yes.
Okay. All right, the court is calling 2020 CR 2650, State of Texas versus Adam Nathaniel Garza. Can I have parties announced for the record, please, for the state,
Meredith McIntyre for the state.
for the defense?
Keith Engelke for the defense.
And are you Mr. Adam Garza?
He's muted.
Yes, ma'am. Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Garza, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you
Yes, ma'am.
understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garza, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garza, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
What you're charged with is burglary of a building with intent to commit theft. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's
does.
currently competent and was legally sane at the time of the offense?
In my opinion, he was.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 12 months in the state jail facility. There's a $1,000 fine and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then Mr. Garza, to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. The state moves to admit State's Exhibit 1 and all attachments.
Any objections?
No objection, Your Honor.
Mr. Garza, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
No objection to proceeding with sentencing.
Anything you
Yes,
wish
Your
to say on behalf of your client?
No, ma'am.
All right, then the court will follow your plea bargain agreement. The court will sentence you to 12 months in the state jail facility. There's a $1,000 fine. Time and money will run concurrent. The court will give you credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Garza, you're gonna have to get your life together. Otherwise, you're gonna find yourself in and out of prisons and in and out of jails. Do you understand?
Yes, Your Honor.
Know better, do better.
Yes,
All
ma'am.
right. Have a great rest of your day.
You too,
Thank
ma'am.
you, Mr. Eagle P. Oh, thank you very much. All right, Norma, can you let them know that L16 can go back?
Yes, ma'am.
May I be excused, Your Honor?
Yes.
Thank you.
Everyone, just give me a moment.
Yes, ma'am. Leave meeting on.
Yes, you're excused. All right, and Mr. Engelke, you're excused. Anyone else ready to proceed?
Judge, Mr. Latimer needs to go into a breakout room with his client.
Mr. Garza is not on the screen. His client. I'm sorry, Vasquez Tellez. Ah, there you are. They had you listed under a different name. All right, Mr. Latimer,
Yeah.
If you go to breakout room number 2, please.
All right, thank you.
All right, Norma, who's the attorney for Meager?
Give me 1 second, Judge.
That's why these guys were all laughing.
Man, you know where the ISF is gonna be at?
It's Glenn Payne, Judge.
We'll need Mr. Payne here then. And we also need Alfonso Cabanas.
Yes, ma'am.
Thank you. All right, everyone, we're going to be taking our break at 12:15. So we will see where we are in just a moment.
Judge, I sent you a chat.
Okay. And he's from Meager, is that correct?
Yes, ma'am.
All right, Mr. Meager, your attorney has asked if he could come this afternoon. And sometimes attorneys, they have more than one case. They have numerous courts to be in, and a lot of them are out of county sometimes. So we're going to bring you back this afternoon at 2. All right, Norma, if you can let them know that if we can have him back at 2, please.
Yes, what seat is he in, Judge?
He's in L9.
Thank you.
All right, Mr. Stateson, you're back.
I am there. There is no change in the offer. It remains the same. May I go in a room to speak with Mr. Kelly before we make any update announcements?
Yes. Mr. Kelly, I'm going to send you to breakout room number 3.
All right.
All right, yes. Let me just find you on the screen. Just 1 second. There you are. All right. And Norma, who's the attorney for Hernandez in 12?
That's Alfonso. I'm trying to get a hold of him.
All right. Thank you.
Have we heard from Attorney Glenn Payne this morning?
Yes, he's going to come back at 2 p.m. on Mr. Meager.
Okay.
I think he's zooming in another courtroom.
Judge, is that what time we're picking up this afternoon is 2, or are we doing 1:30?
No, we're going to pick up this afternoon at 2. That way everyone can get prepared for 2. Okay.
Judge,
Yeah, I threw everyone off schedule. Mr. Kelly, if you can go to a breakout room, please, number 3.
okay. Am I supposed to get an invite, or how do I get
Now,
to
if you look on your screen at the bottom, you should see where it says participants or chat. And then you should see 4 little boxes that say breakout room.
Judge Boyd, Joseph
Yes.
Staten here. Joanne de Hoyos is traveling to Zavala County. She's going to pull over. She's going to try to join Zoom in a minute or 2. If you can be on the lookout for her and put her in the room with Kelly and I.
Yes, I will. Norma, can you have one of the deputies help Kelly to go to a breakout room, please?
Yes, ma'am.
And it's number 3.
Excuse me, Judge, Your Honor.
Yes.
Do I stay here or? do I
No,
go-
someone's gonna come and remove you. They don't like
Okay.
us to have everybody wandering around, but we're gonna have you back here at 2. And the court coordinator is calling to the jail to let them know that we completed your case. If you see a deputy around
Uh-huh.
who happens to be walking past you, just let them know you have to be back at 2 o'clock.
Okay, yes, ma'am. So I got permission to leave though, right now?
No.
Oh,
Just
okay.
remain in your seat, okay?
Yes, ma'am. Yes, ma'am.
Joanne, I'm gonna send you to breakout room number 3.
Judge, I was like, boom, boom. As soon as she popped in, so fast.
You are awesome. Hey, you're wearing the lavender bow tie today.
Yes, ma'am.
All right, everyone, I'm going to read some documents. When someone's ready, just let me know. Michael Latimer, what is happening with Mr. Vasquez?
Yeah, I spoke to Mr. Morris. He's given us an offer. I've talked to my client. I'm going to send him a report regarding all 3 cases and the offer. We're going to probably accept one of the offers made by the state.
Okay.
So if I talk to Norma about a reset date?
All right. Do you need a week? Is that enough time?
Well, no, I'm going to probably send the report to him next week. Maybe 2 weeks is fine.
All right. Could you have your client come out of breakout room number 2, please? If you'll go back to 2, have him come out of number 2.
I'm sorry, you want me to go into 2 and then have him come out of 2?
Yes.
Oh, he's still in the breakout room?
Yes, he is.
Okay, let me tell him to get leave. All right.
How many other cases does Vasquez Tellez have?
Judge, he has a misdemeanor ABI and then an unindicted 4 to 200.
All right. Norma, can you give me a 2-week reset on Vasquez?
Yes, ma'am. He can come back on the 29th.
Okay. All right, Mr. Vasquez, we're going to bring you back on June 29th. Oh, I'm sorry, you muted yourself again.
Oh, I'm sorry. Yes, ma'am. Oh, that's fine.
All right, so you're going to come back on June 29th at 9 a.m.
Okay, not a problem.
All right, Mr. Latimer, did you need to speak with him anymore?
No, that's, I'll be going to visit him. Thank you.
All right, thank you. You're excused. Norma, can you let them know that 17B can go back?
17B. Yes,
Thank you
ma'am.
much.
Thank you. And Norma, on Mr. Hernandez, let's just bring him back at 2.
Yes, ma'am.
Hello, Joseph, you're back.
I am back. We were able to confer with Joanne and Kelly, and we can update you on the latest.
Okay, what is the update?
Okay, so I conferred with Hunter. There is no change to the offer. There is no better offer they could make. Mr. Kelly is not going to take the offer. We are going to file motions for trial motions, but we're going to ask for a pretrial conference to make a rule for you to have a ruling on them. And we're going to schedule a conference to go over the video discovery with Kelly, but we need a trial setting.
All right, Norma, the defense is going to want a jury trial on this case. What date shall we put it on for jury trial?
Yes, ma'am, give me 1 second. Let me look at the. Give me just a moment, Judge.
Do we have a number? I'm sending you a message in the chat.
Yes, ma'am. I sent you a message back, Judge.
All right, defense, are you okay for August 6th for jury trial?
Let me check Joanne's calendar. I know that she does have jury trials in other counties now that are starting. Let me check. August 6th.
Yes.
I believe that's a good day. August 6th jury trial. And is there a call docket before then?
No. So any motions that the defense would like heard before then, let the court know. If it's
Okay.
going to be a motion to suppress or anything of that nature, that will be carried with the trial.
Okay.
And I'm sure if you all confer with the state, whatever you're entitled to, I'm sure they'll give to you without us having a hearing. But again, if you need a hearing, let the court know.
All right, Your Honor, I understand. I'll reach out to Hunter about our motions.
All right, and Mr. Kelly?
Yes,
Oh.
ma'am.
All right, the only other date, Mr. Stetson, is June 21st.
What is on?
I mean, we can stay with August 6th, or I can put you down for June 21st for jury trial.
We'll take the August 6th. That way we can timely file motions. We had expected a plea last week, so if we could have the August 6th and file the motions, and
I like June 21st.
we would like to review the video with Mr. Kelly.
All right, let's go on the record just briefly. Court is calling 2020 CR 8051. Could I have parties announced for the record in the matter of State of Texas versus George Ryan Kelly for the state?
Hunter Morris.
For the defense?
Defense counsel Joseph Stateson making an appearance for another attorney, Joanne de Hoyos. Joanne de Hoyos represents George Kelly. I'm an associate attorney.
All right. And are you Mr. Kelly?
Yes, ma'am.
All right, Mr. Kelly, you're requesting a jury trial, is that correct?
Yes, ma'am.
All right, what that means is that a plea deadline date was given, and because no plea has been reached, your plea deadline date has expired, so the court will move forward towards a jury trial. Defense, the available dates for jury trial are June 21st or August 6th. Which date would you prefer?
Defense counsel would prefer August 6th, Your Honor.
State?
August 6th is fine, Judge.
All right, so your jury trial, Mr. Kelly, will be August 6th. Do you understand?
Yes, ma'am, I do.
All right, if Mr. Kelly, you were to hire an attorney, that attorney needs to be ready for jury trial on August 6th, because on August 6th, you will have your jury trial. Do you understand?
Yes, ma'am.
All right, and Mr. Stateson, if you all are still on the case, could you make sure that Mr. Kelly is appropriately dressed for trial?
Of course, Your Honor.
All right, thank you. Is there anything else from either side before we close the record?
Nothing from the state judge.
Nothing from defense.
All right, we'll close the record then. Norma, can you let them know that 14A can go back?
Yes, ma'am.
Thank you, Judge. May I be excused?
Yes, thank you. Who is Madeline R. who's listed? Does anyone know who this is? I don't see her on the docket. All right, everyone, I'm going to stop live stream. We will recess until 2 p.m. and at that